Okay, again, this is Jason Tellerico of One Timers. Now we're going to do essay 4 for the 2020 February bar exam. And this one has to do with PR and evidence, from what I understand. Now, this essay gave, I guess, essays 4 and 5 gave most people fits, and rightfully so. And we just, finished essay 5, and I can see why that would be a difficult essay to get through. But again, one of the best ways to navigate through an essay is going back and just breaking it down step by step and discussing each thing as it occurs. I think on the second read of question 5, it became much clearer about what to do and how to do it. I'm sure if I even did it a third or fourth read, I'd probably even see 1 or 2 things that I didn't pick up on the first 2 reads. But in the interest of time, I'm not going to go through that yet again. So let's move on to question 4. And the examiners looks like they've learned from their mistake, because the bottom of the page says question continues on next page. Now, there's only been 2 essays in the history of the California bar exam to be beyond 1 page. This is the second one. The first one was, I think, during the pandemic. Was it 2020 October, I think? I don't know which one it was. It was somehow, or maybe 2021 February, where they did not say continue on the next page, and several students did not look at the next page, although it would be logically weird, because here's the thing. Do you know how, even if they didn't put continues on the next page, do you know how you know it continues on the next page? Anybody know how you can tell? I'm going to take a shot at it. Here's why. They wouldn't have a number 1 there. It would make no sense to have a number 1 followed by A, B, C, and D. It makes no sense. So there would have to be a 2 after the 1, because it would logically, if anyone's ever done the Harvard outline approach, it would logically make no sense to put a number 1 there. It would just eliminate the 1, and then Ben's testimony would be A, B, C, and D, and there would be no 1. So a 2 has to follow a 1 according to proper outlining. So here we go, and we turn it to call number 2. Notice at the end of call number 1, it says answer each according to California law. And at the end of call number 2, it says answer each according to California and ABA authorities. That's how you know call number 2 is professional responsibility. And call number 1 can be obviously evidence. If we're in California civil court, it could be California civil procedure, community property, or wills. And that's what you have. But you know for a fact call number 2 is PR, because the call will only say answer according to California and ABA authorities of its professional responsibility. Okay, so let's go to call number 1. Assume all proper objections have been made. Does everybody know what that means? Because it still blows my mind that students don't understand what that means. Andy, you want to answer it for me? Andy?
Would it be that certain issues wouldn't be able to be brought up? I'm trying to go off my memory.
No, I'll tell you what it means. All right. So in evidence, does everybody know when you're at trial, you have, Eric, you probably know this, you've been in trial, right? You never been in trial, just all transactional? Wow, after all that time, man. Okay. So if anyone's ever been in trial, I've been in trial, and one of the things you know, if you don't make an objection timely, you lose it. Here, we're at the end of the case. So the objections couldn't have been timely if you're making the objections now. That's why it says, assume all proper objections have been made. And if you don't believe me, go back and look at every single California bar exam essay that's ever tested evidence, and that phrase is there. That's the only thing it means. So you can't pick it apart on terms of timing and saying he waived all his objections because he waited till after trial and it's now over and it's a moot point. You can't do that. They're saying don't do that. Don't be that snob. Don't do that. They're assuming all appropriate objections were made. They probably should say assume all timely objections have been made. Should the following items be admitted into evidence? A, Ben's testimony. Okay. B, Anna's testimony regarding Dan's statement that he was with Frank the night of the murder. So I know it's a criminal case. So Ann's testimony regarding Dan's statement, well, Dan, I assume, is probably the defendant, and that would be an admission, but it seems like this right here, Ann's testimony regarding Dan's statement that he was with Frank, that seemed to be not used against him. This looks like it might be in favor of him. And as you know, an admission by a party opponent, or what's called an opposing party statement, cannot be offered in support of your case. It can only be used against you. Most people don't realize that. I've seen MB questions test that, where it's like, hey, no, but I told the officer that I wasn't speeding. Objection, that's hearsay, because I can't use an admission, or what's called an, it's not technically an admission, you're not admitting guilt or anything. It's just it's a party opponent. It's just a statement by a party opponent, but it can be used against them, not in their favor. So I have a feeling B might be used in his favor. C, Anita's testimony that she had received the bloody pants from Ben and turned them over to the prosecutor. All right. So I can't imagine why she wouldn't be able to testify to that. It's physical evidence. She's obviously a recipient witness. She has complete knowledge of what happened. And she got him from Ben and she turned him over to the prosecutor. Okay, that's fine. I mean, that's generally what you would do. I mean, if somebody handed me the murder weapon, I just got a free gun. D, Anita's testimony that Ben told her that Dan said he had killed Victor. That's got to be hearsay. That's got to be multiple hearsay. Because Dan's statement to Ben would be because now it's being used against Dan. So there's an opposing party statement. But Ben telling Anita, well, unless that falls into exception to hearsay, I can't imagine how that's coming in. So I'm feeling pretty good about this one. I'll be honest with you. So far, so good. Answer each according to California law. So now I know it's California evidence. Number 2, what ethical violations did attorney Anita commit by turning over the bloody pants to the prosecutor? Okay, did she breach confidentiality? Now we're talking about ethical issues here. Would I want to see somebody, Warren, if you can hear me, would you discuss the attorney-client privilege in call number 2?
You're asking me?
I'm asking Warren.
I'm Warren.
I'm sorry, Warren Smith. Warren Smith.
Warren.
Okay. How about Samuel? I'm gonna see if anyone's actually paying attention or you just logged in for shits and gigs. Samuel, would you discuss attorney-client privilege in call number 2? Okay. Nar, why don't you tell him? If you remember.
I wouldn't. Wouldn't it just be a confidentiality, attorney-client confidentiality?
Yes. The attorney-client privilege is not an ethical rule. The duty of confidentiality is. The attorney-client privilege is an evidentiary privilege, or what's called a testimonial privilege. It allows you to prevent someone from testifying against you. That's why it's a privilege. Now, it's not an ethical rule. A lot of people get that confused. The attorney-client privilege deals with evidence, not PR. Confidentiality deals with PR. So to me, that's going to be a confidentiality, not attorney-client privilege. An answer that discusses that will just get skipped over on that regard. Turning over the email exchange regarding Dan's alibi to the prosecutor. And then we got withdrawal rule 1.16. All right, so I think A and B are testing similar things. I have a feeling one's going to go one way, one's going to go the other way. Just a guess. Okay, let's take a look now. Deanna's facing trial in Superior Court of California for the murder of Victor. Finally, we got, like, I didn't like that Jim, Fred, Chris, Selma essay because of the names. I just didn't like the fact that the names. Now we got the names right. D, defendant, V is Victor. All right, so he's murder of Vic, criminal case. And for a criminal case, it's interesting, which most people don't realize, character evidence is most likely to be admissible. It's the only thing that's broader in a criminal case, and now we're in a civil case. In civil cases, civil's war, it's all coming in, pretty much everything's coming in except for character. Whereas in a criminal case, pretty much nothing's coming in except for character. And that has to do with the 6th Amendment to the Constitution. Criminal defendant has a right to present a defense, and you can't have a federal rule trump the 6th Amendment because of the Supremacy Clause. The 6th Amendment trumps any federal rule. So if the federal rules say you can't introduce character evidence, the Constitution gives the defendant a right to present a fair defense. And that's why character evidence is most likely to be admitted in a criminal case. I'm not saying there is character here. In fact, I doubt it is because none of the calls really brought up character, but I'm just making that point. Okay, so Dan entered into a valid retainer agreement That's the examiner's way of saying you're not going to have time to discuss contingency cases and criminal or retainer agreements or any of that stuff. You don't have the time. It's a valid retainer agreement. Move past it. With attorney Anna for her to represent him. Fine. And we have to assume the fee is reasonable, all that stuff. Don't get into it. You're not going to have time to get into it. And you're not going to get any credit for it. Anna met with Dan to discuss his defense. Got it? I wonder if he's in jail. In the interview, Dan claimed he had spent the entire evening when the murder occurred with his father, Frank. Okay. Wait, Anita's going to testify? What the hell? She got no. What? Anita's the attorney, and she wants to testify to this. What the heck is going? Wow, that is so weird. Okay, hold on. Wow, wow. In their interview, okay. So no, of course not. I mean, you would wonder. I mean, like right now, from what I've read up to this point, and don't jump on me. I've not read the whole thing. I would assume, like, yeah, sure. Go ahead and let her testify. Dan would want her to testify because it's in his favor. But there's no way that B is going to allow that. You know, one B as a boy, because it's for his favor. It's not used against him. No. And even if it was being used against him, it would be the attorney-client privilege to prevent her from being able to testify. So I'm just thinking out loud right now. The next day, Anita sent an email. I know the email was in the call. And this is where she violates an ethical rule. An email to Dan expressing her concern that his alibi was weak. Okay, that's her notes or mental impression. That'd be a work product. Of course, but that's not a PR issue. Work product's not a PR issue. Dan replied to the email and admitted he had lied about his alibi, but denied that. Oh, that's why she could testify. He lied about his alibi. Oh, so now, okay. Remember the differences between. Well, shit. Turning over the email exchange. Oh, Jesus. Denied that he killed Vic. All right. So he's lying about his alibi. So she can't put him on the stand knowing that he's gonna lie, and that's part of the lawyer's duty of candor to the court. In California, you can put him on a stand, but you have to let the narrative version go. Like, okay, what happened that night, and just throw your hands up and let him talk and let him talk and let him talk. You know, that's your way of signaling to the judge and the opposing counsel that, hey, I don't want any part of this. I'm not doing anything ethical, but my professional responsibilities forced me to put him on the stand against my better judgment. So, okay. All right, interesting. Anna visited Dan's apartment and spoke with Dan's roommate, Ben, and Ben's testimony is there, who said Dan confided in him that he killed Victor. All right. All right, so Ben's testimony. So Ben, okay. So that's going to be, that's going to be a opposing party statement, which under the federal rules is non-hearsay. Under California, it's an exception, but that's irrelevant. Ben gave Anita a pair of Dan's pants that were covered in blood. What a dick. I mean, seriously, who needs a roommate like this? This is the fucker we should have killed. The next day, Anita gave the prosecutor the bloody pants in the email exchange about Dan's alibi. You know, I could see the bloody pants because that is physical evidence, and physical evidence doesn't lie, which is why a Miranda violation allows you to introduce physical evidence and not statements, because physical evidence doesn't lie. You know, if I said the body was buried in the woods and you find the body, you can't say you coerced me to tell you that. How the hell did I know the body was there? But if I said I killed somebody in a Miranda, that statement could be suppressed. Forgive the noise. Nothing I could do about it, unfortunately. And Wednesdays are not the best day for that. Okay. So should she have turned over the bloody pants? I believe so. I think she has a duty to do so. In fact, it's in the official comments of one of the rules where you have to do that. But the email exchange, there's no reason why. This is all confidential information. She's breaching her duty of confidentiality there. Okay, so you can see the difference between, and I knew that was going to be the case just by the calls. In call number 2A and B, there's going to be two different things. Anita then decided she did not want to represent Dan any longer because she was Tired of his lies. Ah. Oh God, can you just dump a client because you don't like the fact that they lie? Well, Corey, how do you know a client's lying?
Their lips are moving.
There you go. Good job, Corey. Their lips are moving. Clients freaking lie. You know, if you really want to see a fairy tale, watch a police officer on the stand. It's just magical. I mean, it's like reading a Harry Potter novel or the Bible. You're going to not get any truth in any of those things. Okay. So can you drop a client because of the lies? That would be obviously call number two is C is in Charlie. I mean, if they're asking you to break, he's not insisting that she break any ethical duties. Now, clients will lie to you, and this happens. You'll catch clients in lies, and you know, and a good attorney, well, at least an ethical attorney, will say, "Look, I can't allow you to lie on the stand." But when a client does lie to you, you should explain to them what your responsibilities are. You don't just drop them. And if she has some kind of moral reprehensible, she's in the wrong profession, first of all. I mean, some people won't represent child molesters, and they won't represent rapists, or they won't represent murderers, or whatever, their gang members, or whatever the case is, for their own personal reasons. And that's fine. You don't usually take on the representation. And if you somehow are forced for the representation because you're a public defender or you're on one of those lists, you could probably withdraw for that reason because it's morally reprehensible to you. That would allow you to withdraw, but I don't know if this would allow her to withdraw. She petitioned the court to withdraw. Okay, the court granted permission for Anita to withdraw. That's interesting. That's pretty quick. Frank then immediately hired another lawyer to represent Dan. Frank's his dad. Oh, okay. Well, they're not getting into third-party payments or anything like that, because like, who would the duty of loyalty be to? You know, that's actually one of the ethical rules, but they're not asking about that. At Dan's trial, the prosecution calls Ben as a witness to testify to Dan's statement that he killed Vic. So keep in mind here, how many calls of the questions do we have? We have 7. 7 calls of the question. What does that mean? Erica, what do you know when you have 7 calls of the question? You can tell something really quick.
A few of them are going to be really fast, and some of them are going to be like the main.
Yeah, they're not all going to be home runs. They're all, I mean, in fact, with 7 calls divided into 60 minutes, minus the time you have to read, you're probably talking just a few minutes for each question. Okay, assuming they're all equal, and we're not assuming they're all equal, but even so, it's like you're not going to spend more than, you know, this isn't like these are going to be real quick. So Ben's testimony, to me, all I see is, yeah, this is a opposing party statement. Sure, it's coming in. He said that he killed him. Why can't Ben testify to what Dan said? I mean, Dan has the opportunity to cross-examine him. There's no problem there. Okay, so Dan's statement that he killed Vic. Yeah. The prosecution then called Anita to testify. Whoa, there's the attorney-client privilege in 1B, because the prosecution cannot call Anita to testify. That Dan's statement that he'd been with Frank on the night of the murder. That's attorney-client privilege. No. You can't get it now. No, you can't get the attorney. No, that's attorney-client privilege. So opposing party statement, admission, give me a second. 8C privilege. Yeah, that's gonna be privilege in B. Anita received the bloody pants from Ben and turned them over. Oh, shoot. That Anita had received the bloody pants from Ben and turned them over to the prosecution. So they went and needed to testify to that. Ooh, shit. Oh, no. I don't know how to handle this issue precisely, but it's going to be different. This one, though, probably because B, I know that she's not going to be able to testify to what he said there. That's clearly falls within the privilege. Because don't forget, even with the duty of confidentiality and the attorney-client privilege, there's what's, you know, there's the joint, you know, there's a joint crime fraud exception for both. So if I'm using the attorney's client, the services to commit a fraud, that could eliminate the attorney-client privilege. It also allows the lawyer to reveal confidential information. But forgot my point is here. I lost my train of thought. So the fact she received the bloody pants, so answer choice 1B has nothing to do with the future crime. It has to do with the past crime. I mean, and that's the whole point of the attorney-client privilege. So your client can tell you, look, I did do this. I did kill the person. And that'll let the lawyer know, hey, we might have to set up a defense where we plead guilty and get you the least possible sentence and try to go to trial knowing we can't win for whatever reason. So that's why the attorney-client privilege and the duty of confidentiality is so valuable to the client. So the client can be honest with the attorney, although they don't usually are because they don't know any better. And I don't blame clients for lying. They're scared. They don't, they don't want to go to jail. But turning over the bloody pants, I think she's gonna have to testify to that. And I think the attorney-client privilege, there's got to be some kind of this is physical evidence. I don't know what the actual exception is here and have to look that up. But I know somehow that physical evidence, she was given it to her, she was there, she's the recipient witness. She's got to be somehow able to testify in chain of custody. I mean, at least to the chain of custody, like, hey, I received it from Ben, it was his roommate. We don't know, of course. Here's the relevant part. Do we know whose pants these are? Let's see here. Ben gave, a pair of dance pants. They said it was a pair of dance pants. So you can't argue that, hey, we don't know where we got these pants. It says it's dance pants. And Susan, Charlie, I would do my best to wing it if you didn't know it. I would do the best to understand that physical evidence. What's that, Amina? You had something to add?
No, I wasn't raising my hand. I was just thinking what you were thinking. I didn't know what the hell to do with that. So I winged it with maybe possibly if she owed a duty to under discovery to turn over discovery. I didn't know what to do with it. That was the only one I couldn't figure out.
Tisha, what do you got?
Well, I said that attorney-client privilege didn't apply because it says it protects communication.
Yeah. Okay, so that's what you did in Susan, Charlie, correct?
But the code of the question simply asks if this
Hold
should
on.
be admitted.
Fabiola, we don't just, we're trying to have a discussion here. And please raise your hand. I appreciate you speaking, but let's just do things with a more organized fashion. Tisha, you were saying for 1C, that's what you talked about, the communications and not physical evidence, right?
Right, that's correct.
Yeah, and you'd be correct on that, which I think you said it in definitely a more concise manner, but I was kind of like circling around with that about like, are you trying to get, it's physical evidence. And so, yeah, I think the way that she said it is much more concise and easy to understand. Attorney-client privilege protects communications, not physical evidence. Thank you for pointing that out for everybody. Really appreciate that. Now, Fabiola, did you have something you'd like to add?
Yeah, the call of the question simply is asking if these items should be admitted or not. So that it's with physical evidence, they should, unless someone has more details about those rules.
But realize something, Fabiola, they're saying, should her testimony have been admitted? The part of her testimony where she testifies about receiving the bloody pants. We're not really concerned about introducing the bloody pants in evidence, although, it's very similar. It's like, could she even have testified to that? Could she have gotten to the stand and testified to that she received it? Make sense?
Yeah.
But you're on the right path though with what you were saying. Okay. So moving on, and that Ben had told Anita that Dan said, well, Ben had told Anita. So we want Anita's testimony that Ben had told her. Well, Ben's statement to Anita's hearsay. And there's no, and it did say that, so they want Anita, no, you might even have a confrontation clause problem, hearsay. Well, no, because you already had Ben on the stand. Anita's testimony that Ben had told her that Dan said he had killed Victor. So this is multiple hearsay. And so we go from D to B, which as we already discussed in 1A is a statement by a party opponent or, admission, whatever you want to call it. But from B to A, no, there's no exception from B to A that would allow it to come in. So that'd be hearsay. So then they'd have to strike that. So Anita would not be able to testify. So it looks like Apple and Charlie are coming in. Boy and dog are not coming in. Okay. What ethical violations did Anna commit by turning over the bloody pants? Well, when it comes to physical evidence, like the duty of confidentiality, it's very similar to like what's going on in 1C. Now, Fabiola, they're talking about, well, they're talking about the bloody pants now, turning them over to the prosecutor, which I assume the prosecutor is going to introduce them into evidence. Obviously, 2B has to do with the duty of confidentiality, that she breached that because there's no reason for her to have turned over the emails. We already discussed the withdrawal and whether or not it's reprehensible, whether or not he's insisting that she violated an ethical rule. And even if he wants to testify, she has to be able to put him on the stand, at least in California. So the only thing we're left with the bloody pants. And I think that's going to be very similar, but a little different in terms of like, I think she breaches her duty. She does not breach her duty of confidentiality in 2A. There's got to be there's got to be some distinction that I'm missing here. I just feel it. I can already feel it. Christine, do you know what that is? You seem like to have like a look that you might know. You know what? That essay was not half as bad as what I thought. Go ahead, Christine.
That whole day sucked for me, so I don't know. If I'm being honest, like it blew. So
Yeah, I can see. I mean, I could definitely see that. I'll tell you one thing though. From what about the horror that I heard about this essay, I don't see it. Essay 5 was way more difficult than this. And every time that I face an essay that I believe is difficult, now I'll tell you one thing. Essay number 1 was a complete joke. Essay number 2, the community property one, wasn't as bad. Like on a scale of 1 to 10, essay number 1 was it was a 1. Essay number 2 was probably about a 3. Essay number 3 was the nuisance one. That was about, I'd give it a 4 or 5, only because it was maybe a 5 or a 6 because of the factual discussion. Question number 4 is only about a 6 or a 7. And I'll tell you, question number 5 was about an 8 or 9, about an 8 in terms of level of difficulty. I did not think question 4 was this difficult. I mean, I just don't see the difference. I mean, there's 7 calls to the question, which is nice because you're really able to discuss something with each call with some kind of precision. I mean, the attorney-client privilege, the communications, admission by party opponent, the multiple hearsay, the duty of confidentiality, physical evidence with the emails and the withdrawal. I mean, I just don't see it. Somebody, I'd love some feedback about that. What do you guys think? Go ahead, Corey.
For me, it was the psychological game. I hadn't evolved to the point of seeing like, oh, it's only 7 little small factual or small things I got to hit. For me, it was like, oh shit, there's 7 things I got to get in an hour. You know?
Corey, come on now.
Yeah,
You know I've covered that 100 times.
I know this one particularly got to me.
I'll be honest with you, I like it when there's more calls. Because I'm like, whew, like they're all small, they're all just microscopic. It's like where you got a call law question, like was there a taking? It's like, fuck, I got a whole hour on this taking shit. Or like, ask me multiple calls because I can hone in on exactly, they're actually giving it away where they want you to focus. And so this one really chops it up, I think rather nicely. But go ahead, Amy. Thank you, Corey. I really appreciate that, the feedback. Who else? Go ahead, Tisha.
I think it was more so the subject matter as opposed to the actual cause of the question. It just seems like evidence is very time consuming. It has a lot of rules, whereas the other ones is kind of easy not to get tricked. I had to keep making sure that I was tying the right things to the right pieces of evidence. It can get tricky if you move too fast.
Tisha, you followed up a brilliant comment with one that I'd find not to be your finest. I'll tell you why. First of all, there are no tricks on the exam. There absolutely are none. And please show me where you think there are, because I don't see them. I don't ever see them. Does evidence have a lot of rules? I mean, they really don't even go into, I mean, they only go into like 3 or 4 things here in the entire essay on evidence. Attorney-client privilege, mission by party opponent, a hearsay statement, and that's it. I mean, there were only 3 things here in the evidence that I see. Yeah, and people are like, oh, what about relevance? Fuck, shut up with relevance. Fucking everything's relevant. Every fucking thing is relevant. But I don't want to hear anything about relevance. Yes, you bring it up once, let it go, move it on. 352, whatever the hell Prop 8 does. Somebody still needs, I still need an expert. I've read all about Prop 8 in a California criminal case, in a California state court, and I still to this day, I've talked to DAs, I've public defenders. My one buddy had been at the public defender's office for 6 years. And I said, Mike, what the hell's up with this Prop 8? What does it do? And as a public defender, experienced public defender, he says to me, he goes, I don't know, but we had fucked a lot on it. That's all he said. He's like, he doesn't even know what it is. And I've read it, the Truth and Evidence Act. I've gone through it. I don't understand how it factors in anyhow to anything, because every single exception is all the exceptions that are listed in the California Evidence Code and the Federal Rules of Evidence. And like, I don't know, I just don't see it. I don't see anything under 352 that would kick it out. 352 California is the equivalent of 401 federal, or I'm sorry, 403 federal, where anything that's highly prejudicial is going to get booted. But nothing here is incredibly prejudicial. In fact, everything here is very highly probative, which means it's highly relevant. I mean, how relevant are the bloodstained pants? Extremely relevant. How relevant is the fact that he admitted killing the victim? Extremely relevant. So, anyways, anyone else want to add something to this? Because I don't know where else to go. I would read it. I would read it one more time. In fact, I probably will do that once we break, unless you guys want me to go through it one more time here, see if I see anything differently. Anyone? Lauren?
Yes, can you? Oh,
sure. All right, let's take a look at it. I'm going to do it anyways. Might as well.
Can I speak? All right. On the evidence thing, it wasn't until after the bar exam that I saw some formal opinion on the bar's website about an attorney receiving evidence and how they must notify, well, they must give it to the prosecutor, but they must notify the defendant that they're going to do that, and then give the evidence to the prosecutor. And I thought that might be something that they wanted discussed.
Possibly. Do you have that opinion?
I am looking for it. It's a 1980. It says 1980 opinion. It was. I found it and I posted it somewhere, and I can't find the link now. But it's in one of the formal opinions on the Cal Bar website. There are quite a few of them, and I think one of the here's a competing duties thing that I found, but this is from something completely different. It says liar, liar, pants on fire, the ethical dilemma of the lying client, and that's from May 2014. But that's on the State Bar website.
Oh, put that in the chat box thing, will you?
I'm going to. I just found it. I mean, I'm still trying to find that other opinion. Give me a second.
Okay.
I'm not
While
fast.
you're doing that, I appreciate you bringing that up.
Here's the link, because it was really interesting. It was really fascinating. This question, I hated this question. I love that it compared the 2 different ways of handling evidence. One is the government side, one is the attorney side. But then to find that opinion later, it's like, oh, I really wish I read that before I took the exam. I got to find the opinion. But you can look at this link for the liar, liar thing, but I'm still looking for the opinion.
Really, it's really good. I like this. And it talks about, like I said, the candor to the court. Okay. It looks like this is part of the ethical duties. I'm sorry, part of your CLE. Fabiola.
Just in the second question, I think they would like us to discuss a little bit more about the duty of confidentiality regarding the fact that, the attorney should keep some information as confidential, but unless, under California laws, attorneys are allowed to break this duty, to reach this duty only when they see a future danger of death, which would not apply here. Sorry?
Actually, in California, you can remain silent without saying anything without getting in trouble. So you're not ever required to say anything under California law. ABA, a little bit different, like false evidence and stuff. But California has 2 strict rules. California wants pretty much everything in writing, and California wants you to keep your mouth shut. Those are the 2 strictest rules. That's the thing about differences between California and ABA. But go ahead, you were saying?
Yeah, thank you. Thanks for the, well, it's, I think they just want us to discuss a little bit more about this. Like, what's the difference between the ABA and the California rule about the duty of confidentiality? Probably. I mean, that's, what I'm
Okay,
not sure.
but I
It's
don't
just
see any,
my-
I don't see any of those distinctions making, I don't see how any of those distinctions are relevant here.
Okay, well, just probably about these ethical violations, like if she's breaking this or not, like this duty.
Well,
Maybe
the
someone else
client-
has more comments.
The client hasn't committed, the client hasn't insisted that she break any rules. And we did discuss that, like I said, clients will lie. And then you have to, you should speak to the client about like, hey, look, if you're gonna lie about things, but just because the client lies, you don't have to disclose that. Clients lie all the time.
No, sorry. Yeah, no, I'm talking about turning over the email exchange. So probably that would be something we could discuss, I mean, in the exam, but I don't know if
No,
someone
the
would
email
like to.
exchange under both California and ABA would definitely, the email exchange, absolutely protect it under both.
Okay, thank you.
Thank you, Fabiola. I appreciate your comments. That's really nice of you to partake in that. And although I may have corrected her on one or two things, take it as a learning experience. Don't take the, hopefully nobody ever takes anything. Because my job is here to teach and, and make sure you're on the right track. And I've been wrong. Any one of my students knows, I've been wrong before. I'll be wrong again. I'm not perfect. I'm an individual. I'm a human being, and all human beings are flawed to some extent. And so I do appreciate the discourse and the feedback. And, if I do something that's off, and students oftentimes correct me, and I really, really appreciate it. So, and I always ask for like, hey, what did you guys think? Did you see something I didn't see? So thank you very much for anybody who participates in the discussion. I really appreciate it. Okay, anything else here that we have? Go ahead, Erica.
I was just gonna make a comment about the turning over the bloody pants to the prosecutor. When I saw that, for some reason, it triggered in my head your section in the outline that says the games we play before trial and like the discovery plans. And it just kind of clicked. I don't know if that helps, but.
So let's see here what we got here. I'm gonna open that up. So, all right, where's screen share? Okay, PRL. Okay, let's see what we got here. That's clients, confidentiality, games we play before trial. Meritorious claim, fairness to concealing evidence. Aha, that's there. All right. All right. Yep, okay, there you go. Unlawfully obstructing, again. There you go. And another thing too is you can tell I've done this now. So now we can go right to the rule to comment where it came from. By the way, I was looking over like what the NCBE is doing. Close. Come on. Fairness to opposing party. Paragraph A. There it is. There you go, Erica. Good job. That's what they're getting at. They were getting at fairness to opposing party. Yep. Yep, there it is. And that's 3.4. Okay. Perfect. And as the outline says, yeah, 3.4 comment 2. That's it. Perfect. So if anybody wants that, I will put that in the chat box too. Whoops. There we go. All right, perfect. Well, good. Thank you. That was really nice. I'm great. I'm glad. I'm really happy you pointed that out. Boy, I'm telling you, question number 4 just did not seem to be the monster that you guys that it was made out to be. And question number 5 really was. Lauren, what do you got?
I posted the link to that opinion, and there was something here. I'll just set it. It was something that I think maybe they were looking for. I don't know, but one of the statements in that formal opinion, I can read it. I just posted it in the chat. It's something about the and considering the attorney's legal obligations to his client, and then the discussion about giving evidence to the prosecutor. I mean, you can read it, but like I said, it's lengthy.
Yeah, I'll take a look over. I mean, I tend to read everything that comes across my desk.
Yeah.
I'm just curious. So thank you for saying
I think it was something they wanted.
Well, model answer to be coming. Like I did, by the way, for those of you that don't know, I did finish off question number 1. Updated that. So for those of you, essay 1. There you go. And I think the username and password. So just in case if anyone wants to click on them and see if it works, if that comes up. So we'll log out. Let's see here. Yep, that worked. Okay. Yep, there it goes. So that's finished now. I finished that one. So if anyone wants to re-examine that, and that's all I've gotten done so far, because it takes a while even to do that simple thing. That model answer is 600 words, which is very short, very to the point, concise, and I think is extremely accurate as well. And I cleared up the red line agency. There was no agency theory, which is so interesting. I had to go back and reread it again to make sure I had the parties. I'm like, wait, there was red line because a co-felon got killed. So red line's when a co-felon got killed. Agency is when your agent or yourself, is the one who does the killing, and there's no liability if someone besides your agent does it. So that's it. You guys have been great. Today's class I thought was very productive. It was very good. I really enjoyed going through these essays. A little disappointed in myself on essay number 5. I got to be honest with you. I felt like I didn't hit that one as clearly as I could have. But essay 4 I definitely felt a lot better about. And again, you're not going to hit home runs every single essay. That's the whole thing. You don't have to. You just don't want to get a 55. That's really, you just want to stay the course. And I can assure you that with what we covered, if worse came to worse, the worst you would get on an essay that we covered, which I don't want to set that standard so low, but you'd get a 60, even if you just answer everything we discussed. I mean, and a minimum, like, and you did a terrible job even doing that, you would still be able to get a 60, which is really not bad for an essay you don't know anything about. I mean, this is assuming the worst, like, you know what I mean? Okay, thank you very much. If there's nothing else, well, Martin's got a question. Let's hear from Martin.
How could we see a model answer that you said, is your model answer posted someplace?
Yeah, if I get around to it. I got around to that criminal law one because I thought it'd be quick and easy, and it still took me about 2 or 3 days to get through it. But if I do get through one of these, the PR one, before I write that, I'd like to do a lot more research, just because, and even with the torts one with the nuisance, I'd really want to read through tons of things in the Hornbook about public nuisance. And I don't anticipate, I won't even think about writing question number 5 until the selected answers are released. So that leaves question number 2, and I'm really not interested in writing question number 2. So Martin, I don't think that I will be getting to that anytime soon, but if I do, they'll be posted somewhere.
Okay, great. One last question. Are we going to have another meeting on the PT? Because this has been great, and the PT looks like a pretty interesting PT.
We could, but with the PT, I just go through the, I don't really read it, you know what I mean? Because it will take me 50 minutes to go through it.
Okay,
mean,
it just looked really interesting. I'm gonna try to do it. It looks pretty interesting.
Huh. Well, I wouldn't suggest doing it until you get the answer. Because without an answer, there's no point for you to do it, would be my suggestion. Because then how would you know what you did was right or wrong? How would you be able to cross-check it? You would just be on an island and the boat leaves and you have like, okay, well, the PT is 4.2, 5. All right. You know what? Maybe we can do the PT. Let me think about that, Martin. I think probably, yeah. I'll see. Yeah. Let me see. Let me take a look at the PT.
All right, well, these classes have been great, but anyway, whether we do or not, but thank you very much. These have been great and it's been a great experience. So thank you very much. And it's great to make your acquaintance. Thank you so much.
Well, hell, I'm pulling the PT up right now. All right, so we got performance test here. All right, we got 1, 2, 3, 4, 5. Okay, 5, 6, 7, 8, 9. About 9 pages for the library. 1, 2, 3, 4, 5, 6, 7, 8, and about 8. Lauren, I don't know, like you're getting 4.2 and 5.2. It seems to me it's 9 and 8. Where'd you get 4.2 and 5.2?
I'm sorry, not sure.
I'm sorry, I'm speaking with Lauren. She wrote, I won't have much to read. It's 4.2 and 5.2. Oh, no. That's not really helpful. Anyways, I don't think I want to read 17 pages in front of you guys and go through it in the meticulous manner that I go through it. And it'll probably take me about 45 minutes. And I don't know if that's something you guys would want to sit through, is it? Well, speak now. I mean, I can't hear you. You don't say anything.
It would be interesting.
Okay, anyone else?
Yeah, I'd like to hear it.
If you're doing it, I'll come.
What's that?
Yeah, I'd come too.
I'll come.
I did love the PT. It was different.
You're a good teacher.
Thank you, Martin. Appreciate that. You know what? Maybe I will. All right. To be continued. And you guys will see a post, I'm sure, if we are going to do that. And I probably will go through it. Why not?
Thank you. Thank you.
A pleasure, Rose. Always a pleasure. Okay, everyone. Thanks again.
Thank you.
And
Thank you.
I'm sure I'll see you soon. Peace.
Thank you. Thank you. Thank you so much. You've been helpful. Thank you.